Good morning, everyone. Welcome to the regularly scheduled meeting of the Board of Public Works for today, Monday, November 25th, 2019.
Commissioner Villegas, Garcia, James, Davis, and Coloza are present. President James, you do have a quorum. May we start with Bureau introductions, please, starting with Bureau of Engineering.
Good morning, Maria Martin, Bureau of Engineering.
Good morning, Hector Banuelos, Bureau of Streets LA.
Good morning, Sandy Trum, Bureau of Street Lighting.
Good morning, Mark Shin, Sanitation.
Good morning, Brett McReynolds, Bureau of Contract Administration.
Good morning, Ted Jordan, Public Works General Counsel.
Fernando Campos, Executive Officer. President James, we did receive one speaker card under general public comment. We have no commentary under the Neighborhood Council comment section. We also received speaker cards on all the items for today's agenda.
Okay, let's, first of all, agenda item number 6 has been a request by the Bureau to continue the item to Wednesday, December 11th, 2019. So without objection, we'll continue that item to Wednesday, December 11th. I've got December 11th. What day is a Wednesday? What day do you want? Oh, it's item 6. Oh, I thought you meant December 6th. Oh, okay. Yes, agenda item number 6, Wednesday, December 11th, 2019. Mr. Sachs on general public comment.
Yes, thank you. Good morning, Arnold Sachs. Hope everybody had a good weekend. Since I'm going to touch a little bit on Hollywood, I would start by saying in the movie Saving Private Ryan, there's a line by Tom Hanks who says, "I think we're in a surreal moment." Very important. So anyway, yesterday, Football Sunday, Tom Brady almost looked mortal. But I liked the other game that was going on, the Oakland Raiders and the New York Jets. 1968, there was an Oakland Raider New York Jet game. Changed television. Created the source for ESPN. The game was being played in, I believe it was in New York. I don't remember. But I know it was a back and forth contest. This is when the players, Joe Willie Namath, Big Ben Davidson, Darryl Lamonica, all these players, Hall of Famers. But it was down to the last 2 minutes, and 7 o'clock came along, and it was the Heidi Bowl. They preempted the finish of the game so they could put on a TV show called Heidi Bowl. Blew up the television consoles for the operators at NBC. Changed the concept of television. Golden age of television was over. The golden age of sports broadcasting started. Really weird. Welcome to Hollywood. Anyway, that being said, I'm somewhat concerned because nobody has taken any action on doing anything about trying to get people off the streets with the Affordable Care Act, through the Affordable Care Act. There's no action being taken by the city council. Oh, yeah, well, they did. They rescinded the use of single-use plastic bottles. Really good idea. Very, very, very environmental. I'll have a, and by the way, if you've been reading the comics lately, everybody's in on this argument. It's really fascinating, somewhat.
2 minutes.
Thank you.
Thank you, Mr. Sachs. No other general public comment cards, so we will close general public comment. Agenda item, don't go far, Mr. Sachs. Agenda item number 5 is an item returned for signature. The mayor and city council have approved and authorized the Board of Public Works on behalf of sanitation to execute 5 pre-qualified on-call contracts for environmental site assessment and technical support services for the Brownfields program. Mr. Sachs, you put in a card on number 5.
Yes, thank you again, Arnold Sachs. And for those who aren't watching or don't have this on TV, I have my green glasses on, environmental. I'm supporting city council's action. Anyway, stupidity lives. What are the Brownfield Works, the Brownfield program? Just out of curiosity, maybe there are people that know about this, but me being stupid, and I'm not sure if there's other people as dumb as I am who would want to know about that. And Again, on-call contracts, pre-qualified. How do you get on the list to be, well, I guess you can't get on the list because it's already pre-qualified. How does the city work? And who are the pre-qualified companies? And who owns these companies? Even more important, because a lot of times things happen in city council and they end up owning the companies that are getting the work for the city. And so essentially what they do is they don't work for the people who live in the council, they work for themselves. It's a fascinating, fascinating city. I mean, really, you really have to listen and take part in some of the politics, and you find out, what's his name? When Reardon was out of office, he said there's two major downtown clubs. One is for the people who run the city, and one is for the people who own the city. And it stays the same no matter what. That's really, really, that's pretty nasty when you think about it. It just totally cuts out people from any kind of hope to be able to make any changes to this insanity that is LA. Thank you.
Thank you, Mr. Sachs. This is an item that's come back for signature. Is there a second to my motion that we adopt agenda item number 5 forthwith by Commissioners Caloza and Davis? Any objection? Without objection, we will do so. The minutes presented for approval are from Monday, November 18th, 2019. Is there a second to my motion that we approve those minutes? By Commissioner Garcia. Any objection? Without objection, those meeting minutes will be approved. Agenda item number 1 is from Streets LA. It's a requested tree removal at 1000 West Temple Street, recommending that the board find under the California Public Resources Code, Section 21166, and under the state's Environmental Quality Act guidelines, Section 15162, on the basis of substantial evidence contained in the whole record, that since the city's prior certification of the mitigated negative declaration, that's the M&D, there have been no changes to the project, changes with respect to the circumstances under which the project is being undertaken, or new information of substantial importance concerning the project, which would cause new significant environmental effects or a substantial increase in the severity of previously identified significant effects, and therefore no subsequent M&D, supplemental M&D, or other analysis is required for this project. Secondly, specify that Streets LA, Urban Forestry Division located at 1149 South Broadway, is the custodian of the documents or other material that constitute the record of proceedings upon which the board's decision is based. Third, review and approve the request for a fee permit for the removal of 16 rusty leaf fig trees. These are a type of ficus tree. Tree replacements are required. And fourth, concur with Streets LA determination that the site cannot feasibly accommodate all of the required replacement trees, and therefore pursuant to LA Municipal Code Section 62.177C, authorize the tree replacement guarantee fee to satisfy the board's tree planting requirement. Mr. Banuelos, Mr. Sachs has a card in on number 1.
Yes, thank you again. Staying green. And we're talking about trees. Didn't I believe Mayor Villaraigosa, when he was mayor, he put in a program for planting 1 million trees. And I don't know what the standard is on that right now. It would be interesting to have an update somewhere. Also, because they're taking out these trees, what is the condition of the sidewalks around the trees? They're going to have to dig them up. They're going to pull them up by the roots. They're just going to fly a helicopter over, grab them by a hook, and yank them out? Well, who knows? Like a tooth. Who knows? It would be a good time for the city to look into replacing and clearing this, making sure the sidewalks are taken care of. And what are they going to replace them with? It doesn't say. And also the tree replacement guarantee fee. Who gets the tree replacement guarantee fee? Because they're not going to plant all 16 trees back or replace all 16 trees. So there's a lot of questions on a simple item like this. Too often, simple items just get passed, thrown under the bus, and off we go onto the wild blue yonder. I like to ask the questions. I feel it's important, based on the fact that the city isn't acting on any of the sane ideas that come before it. You might as well ask questions about the insane ideas that come before it. Thank you.
Thank you, Mr. Sachs. Mr. Banuelos on number 1, and I know from the board report, Mr. Banuelos, that there was a request by the applicant to remove a significantly larger number of trees than we're actually removing. Maybe it was 31 versus 16 or something like that, if I remember from reading this.
Yes, that's correct.
Okay, go ahead from that point, recognizing that Streets LA was able to, through their more rigorous processes now, save some trees. Go ahead.
Yes. Yes. Good morning, President James, Commissioners, Bureau Representatives, Mr. Jordan, and Dr. Campos. Hector Banuelos with the Streets LA Urban Forestry Division. We have here a request to remove 16 street trees at 1000 West Temple Street at the corner of Beaudry and Temple. This is a site where the developer is constructing a large mixed-use residential project and retail of approximately about 1,150 units of residence and about 30,000 square feet for retail space. The site has 31 trees around, street trees around where Streets LA, or actually we received an application to remove all 31 trees for material staging, sidewalk repairs, and various other project necessities. The Streets LA has reached out to the applicant requesting that they look into alternative measures to see if we can retain the healthy mature trees. In doing so, we have several discussions, we've had some meetings, and we're able to come across where we can save several trees and only identified 16 trees that really need to be removed. There are about 5 trees that were required to be removed for sidewalk for the driveway installations, and the remaining trees were in poor condition overall, and they were identified. Well, we can actually work with the applicant, and we can work with those tree removals and actually set up the material staging. So we're able to minimize the removals needed at this project here, therefore only requiring 16 tree removals. Whereas if approved, the applicant or the developer will be required, there's room to plant 25 trees. The 7 trees that are required to be planted to meet the 2-to-1, we're asking that the Bureau allow the Streets LA, we're asking the board to allow the Streets LA to implement the tree planting guarantee fee to meet the 2-to-1 standard policy. So with that, the Streets LA did review their environmental documents and did determine that the mitigate negative declaration does appropriately address the tree removals and replacements for this project. Therefore, the Bureau is asking that the board approve their request to remove 16 trees for this development project. We received some inquiries from the Community Forestry Advisory Committee, but there was only one request that I seen on the tree removal notification site, and they were just inquiring about the need to remove all trees, whereas in this case we've identified only half of the trees that actually need to be removed for this construction project. Yes. Yes. Yes.
That was James's motion. I realized my microphone wasn't on. Garcia Caloza Davis, second. Without objection, we'll adopt agenda item number 1. Any issue sending number 1 forthwith? We'll send number 1 forthwith. Number 2, Office of Community Beautification, Council District 12, encroachment in the public right-of-way for Granada Hills Improvement Association, recommending that the board authorize OCB to grant revocable permission to encroach within the public right-of-way subject to the listed conditions to, first, the Granada Hills Improvement Association. The encroachment will be of 40 decorative poles with hanging flower baskets along Chatsworth Street between Encino Avenue and Lindley Avenue. They've been wanting to do this for a while. As well as on Zelza Avenue between Kingsbury Street and Los Alamos Street in Granada Hills Council District 12. Secondly, authorize the city engineer to issue a no-fee revocable permit for the work to be performed. Third, authorize the city engineer to issue a no-fee A permit for work to be performed. And fourth, authorize OCB to request the Bureau of Contract Administration to provide a no-fee inspection of the project. Mr. Sachs on number 2.
See, I'm getting better. I started to the microphone before you called my name. Thank you. Arnold Sachs. Couple things here. So we have a no-fee revocable permit and a no-fee A permit. What happens if they didn't get one of those permits? If they didn't get the A permit and they had the revocable permit, what would happen? And on the previous item, there was no permits issued by the city engineer, from the city engineer, and it's a private. That was a private project. They're going to build a huge development again, more huge developments in downtown Los Angeles, without notifying the city, the local public. I don't have a problem with the Granada Hills Improvement District. They used to have fee waivers. Actually, they had a lot of fee waivers back in the 2008, 2009. So revocable permits, who cares? I mean, essentially, they want to decorate the area. Nothing wrong with that. Why they have to jump through hoops to get it done, and why they can't get the city councilman to recognize that we want to improve the area, let's put some hanging baskets up. But then there's other districts, other city council districts. If they can do this work in Granada Hills, can't they do this work in other areas, in the lower income areas where hanging basket, well, they'd be stolen, but essentially some kind of improvements in some of the areas. I mean, there's city councilmen that have been sitting around for 12, 13 years almost, and nothing's changed. It's pretty amazing how these things happen. I guess what they say, the saying is power to the people? No power to the people. Power to the elected official. And kiss the ring, not this ring, that's kiss the ring here. Thank you for your time and attention, by the way. Appreciate it.
That's all right. Thank you, Mr. Sachs. Mr. Valido.
Good morning, President James, commissioners, and members of the board. Jerry Valido, Assistant Director with the Office of Community Beautification. Today I'm presenting an Adopt a Median project spearheaded by the Granada Hills Improvement Association. It mirrors a similar project that was approved by this board 1 week ago. This project entails the installation of 40 decorative poles with hanging flower baskets along Chatsworth Street in Granada Hills. This will improve the visual landscape of Granada Hills and serve as an example that the Adopt a Median program can be of benefit to other communities throughout the city. The Granada Hills Improvement Association has partnered with J&B Landscaping to provide maintenance and watering 3 times per week, as stated in their signed maintenance agreement. Project plans were reviewed and approved by the Bureau of Engineering, and the project has been given support by Council District 12. The Office of Community Beautification requests that we proceed with the permitting phase after the adoption of this project by the board.
Thank you, sir. Any questions at all on agenda item number 2? I know this is something they've wanted to do for a while. This is right up the alley of OCB and cooperating with the community. So I'll make a motion that we adopt agenda item number 2, seconded by Commissioner Garcia. Any objection? Without objection, we'll adopt agenda item number 2. Any issue sending 2 forthwith? We'll send number 2 forthwith. Thank you, sir. Agenda item number, we have 3 and 4, but number 4 we have a speaker card on, so let's take number 4. Hearing ordinance number 181075, termination of franchise agreement for O'Donnell Oil LLC. Recommending that the board first find that O'Donnell Oil LLC submitted a request to abandon its franchise ordinance 181075 pursuant to section 4.7 of the ordinance number 181075. Secondly, find that the abandonment plan submitted by O'Donnell Oil LLC does not meet the city requirements. Third, instruct O'Donnell Oil LLC to submit an abandonment plan which complies with the city and the Office of the State Fire Marshal's requirements. Fourth, authorize the Petroleum Administrator to impose a $25,000 fine for ongoing failure to provide insurance at the level required by the Risk Management Division of the City Administrative Office. Fifth, find O'Donnell Oil LLC is continuing to violate Section 5.2 of the insurance requirements of Ordinance 1810756. Sixth, instruct the petroleum administrator to issue a $25,000 fine for O'Donnell Oil LLC's failure to obtain and/or provide evidence of $25 million in sudden and gradual pollution liability insurance. And seven, an order requesting the Board of Public Works Executive Officer to provide written notification to O'Donnell Oil LLC of the board's action if a representative is not present at the hearing or will not waive notice. We at least have someone present at the hearing. Whether or not they will waive notice depends on what we decide. Let's start with Mr. Sachs on number 4.
Yes, thank you again, Arnold Sachs. Essentially, a real question here is why isn't the city attorney involved in this if they haven't met the parts of the city ordinance that they're supposed to meet? And who gets the money? And on instruction number 3, an abandonment plan that complies with the city and the Office of the State Fire Marshal's requirements. So a lot of times cities' requirements don't, or the state's requirements overstep the cities, and sometimes the cities overstep the states. Who's in charge? That's essentially what happens. It's another one of those situations where you don't know who's juggling the ball. And if they're in continuing violation, shouldn't this be possibly moved to the county district attorney's office? I mean, if the city only files cases, the city attorney only files cases in misdemeanors, shouldn't this type of thing where it's $25,000 fine or failure to comply with the rules and regulations and a first and second or third notice, shouldn't they say, you know what, if you fail to do this, we're going to take action against you with the county district attorney's office? And what, by the way, is the county doing? Don't they have standards for the oil? And where does this franchise pipeline run? What part of the city does it run in? What district does it run in? And are the people that have the pipeline running through their neighborhood, are they aware of what's in this pipeline? This is one of those crackerjack problems that is ongoing. And, you know what? The guy behind me will take care of it. Oh, wait, you know what? And I don't mean any disrespect to anybody in the audience, but there's really nobody behind me. And
2 minutes.
And so, thank you, sir.
Thank you, Mr. Sachs. Ms. Blyther, we'll start with you regarding a summary. I think the board report's pretty self-explanatory, but anything you would like to add for the oral record, we would certainly appreciate before we hear from the representative from O'Donnell.
Good morning. I just want to say thank you. Good morning, commissioners, as well as division department heads. And I just wanted to talk about the franchises in general. And in April of 2018, the Board of Public Works had 42 non-compliant franchisees with insurance requirements. Since then, we've had 2 bankruptcies, SCS Pipeline as well as Whittier Pipeline Vinico. And as of November of 2019, we have 40 pipeline franchises, 30 of which are in compliance with the insurance requirements. So we have a 95% compliance rate. And of the items 3 and 4, those are 2 of those that are not compliant. Specifically for O'Donnell, as you said, the board report is fairly straightforward, but O'Donnell disputed the applicability of the new insurance levels that were sent on March 11th of 2019, and the board found that O'Donnell was required to provide insurance levels of $10 million in general liability, $1 million of automobile and workers' compensation, and $25 million in sudden and gradual coverage for pollution. And sudden is for something like an explosion, gradual is for something like a leak that happens over time. O'Donnell appeared and challenged the charge of insurance and asserted a lack of notice about both the October 26, 2018 and February 25, 2019 board hearings. And the board has addressed O'Donnell's responsibility in the new insurance requirements. And O'Donnell elected to abandon the franchise, citing lack of affordable coverage and disuse its rationale to abandon the franchise. It has submitted 2 different abandonment plans, but neither has been acceptable to the petroleum administrator, as they do not address all the pipelines covered under the franchise, i.e. O'Donnell wants to remove 150 feet of the 2-inch pipeline, leaving nearly 1,200 feet in place, which should be capped. However, more than capping is required. So Section 4.7 of the ordinance requires that those lines be purged, cleaned, sectionalized, and capped and abandoned in any other manner as the Board of Public Works prescribed. This was in the June 21st letter that was sent to O'Donnell, so they're aware of this. And this does not meet the requirements for abandonment because the quote also does not address steep damage restoration, types of permits to be obtained, and it excludes inspection, recompaction, hazardous waste, and other items. So if the city wants to have specific safeguards that will be in place to prevent accidental discharge and remediate any discovered seepage, etc. O'Donnell has yet to provide the $25 million sudden and gradual and for pollution liability. Any questions?
Okay, thank you, Ms. Blyther. No questions yet.
Okay.
Mr. Coffey, I have William Coffey on number 4. As you know, I know you've been before us a number of times, but it's a new record, so I make it clear. We don't put the 2-minute time limit on you. Take whatever time you need. Just if you start to repeat yourself, then I'll think that you're done.
All right, thank you,
Thank
Mr.
you.
James, and thank the board for the opportunity to address this matter. And I did submit a letter outlining
Which we have.
some issues. But there are some factual inaccuracies that form the premise of this request for the fine. First, there's a statement in the report that was submitted to the board that O'Donnell had not complied with the $10 million general liability requirement. That's not correct. They have complied with that. In addition, in terms of the procedural requirements, there's a reference to 3 notices of violation, notices of the second violation, including a reference to a June 18th notice. We have no record of ever receiving that notice, and there was no record of that notice that was submitted in the report. So from what we can tell, there's no evidence, and we did not receive 3 notices as have been referenced in the purported second and third notices of violation. And in addition, there is a statement in support of this fine that the original $10,000 penalty that was assessed at the end of August has not been paid to date. That is also wrong. It was paid on September 23rd, and I've attached the canceled check that shows that. So we believe from a procedural standpoint and a due process standpoint, this doesn't pass muster with all of those violations that I've referenced. Beyond that, as a practical matter, O'Donnell, which is a very small company, is continuing to try to search and find affordable insurance for the $25 million sudden and gradual. Has not been successful to date, is continuing that effort, but has not been able to get that in place. So we've got as much insurance in place as we've been able to afford, which is 3 out of the 4 requirements. And also, we are in the process of locating consultants and other people to put together an abandonment plan that will ultimately be approved by the city, because it's not in our interest for this to drag out either, and that's not our intent. But we strongly believe, in addition to what I've identified as, I think, serious flaws in the process of how this $25,000 fine is being presented, that it's counterproductive to the situation we have here, in which we're simply trying to put together a plan that can ultimately get approved by the city and part ways with the city on this, and we just paid a fine at the end of September, and now we're back here literally weeks later on a premise that we didn't pay the fine when we did. But in any event, it's counterproductive to our effort to try to just get this matter done and resolved. So we would respectfully request the board exercise the discretion that it does have, because these penalties are certainly not mandatory in any way, shape, or form under the franchise agreement. And we're requesting if either the board just determined they're not going to assess a penalty at this time, or in the alternative that they continue this hearing, we've requested for 90 days to give us time to continue working and putting together an abandonment plan that can ultimately get approved, and that's what we would request the board to consider.
Okay, thank you, Mr. Coffey. A couple things, Mr. Jordan, and I appreciate the work of the Petroleum Office on this. Recognize that we may have a bit of a miscommunication here regarding the payment of the penalty. I want to get to that. I remember the hearings that we had regarding the $10,000 penalty. Recollection, you're doing your job. You opposed that. We implemented that. It appears you paid it. We also recognize that your company is trying to abandon, and I tend to agree at this point that an additional $25,000 penalty right now, I don't know that that helps you get to the abandonment that we collectively want to get to. I guess my question, Mr. Jordan, is that my inclination, and I know that we have at least one more light on, but my inclination would be, because we have seen action from O'Donnell, they paid the $10,000 fine, they did obtain some of the insurance, although not yet all of the insurance, admittedly. They're still working on that aspect. I would be inclined to grant the requested 90-day continuance to see if we could get to a point that they can find a consultant that can help them to an abandonment plan that would be satisfactory to the city, put over the hearing on the penalty, because if they can get to that abandonment plan, maybe at that point we could, there's an argument for Mr. Coffey to make to us at that point to withdraw the penalty if they've reached an abandonment plan that works for the city. That's something we can decide later. But I would be inclined to leave that on the table if I can do that legally, Mr. Jordan, as an incentive to see if we can't get to the point that we're both trying to get to.
Yes, I would agree with that thinking, and it was certainly within the board's discretion to defer action on the penalty, particularly given some of the concerns raised by the franchisee, as well as their efforts to achieve an abandonment, which ultimately is also protective of the city if the pipeline is properly abandoned.
Okay, and I realize that it's important to the city that as that abandonment process goes on, that your efforts to obtain insurance happen in parallel fashion. I recognize, though, if we can get to an abandonment plan, then we've made some progress there. And my recommendation would be to put off the penalty at least as an incentive to get there. Commissioner Villegas.
Good morning. I'm wondering, if the city's already provided O'Donnell with time, if an additional 90 days will be able to, is this a matter of time, or is it a money issue?
Well, it's a bit of a combination, but definitely time. But there's going to be more money required to put together the type of plan the city is asking for in order to comply with the requirements, and so that's going to require some resources. And if we have to pay the $25,000, that's just going to undercut that process. In addition, we're still reaching out to other operators and companies and insurance folks to see if there is some kind of interim coverage we could put in place that would satisfy the insurance while we're putting the abandonment together. So it's a combination of time and money, but I think 90 days is a fair request for us to allow us to do that. And I think, as Mr. James points out, we'll certainly have an incentive if we know this hearing has been continued. And frankly, I think our resources are better devoted both to completing an abandonment plan as well as if we're able to find some type of insurance solution in the interim that would also obviate these proceedings in terms of any of the insurance requirements. So
I just don't want us to be in the same predicament 90 days from now.
I hear you on that. I think it's possible that we could be. The difference would be that we would then be able to assess the penalty. We lost the 90 days, but we gave them a shot to try and get to where we were going in. I would be less inclined to do it if we hadn't made some progress with this franchisee from before. Even though there were a number of hearings, we gave them opportunity. They did pay the penalty. They did achieve some of the insurance. And that's why I'm inclined, he's asked for 90 days. I do think that if we get there, then we have a reason to withdraw the penalty. And I recognize they're a small company, and I believe him when he says that the $25,000 could go towards the consultants on abandoning the plan versus a penalty. And that's why I'm inclined to see, at least at 90 days we'll know more, and it's easier to take action. That would be the basis of the recommendation. Commissioner Caloza.
Thank you, President James. I just have a few follow-up questions for our petroleum office. Thank you. Hello. Thank you for your report. I just had a few follow-up questions. So you mentioned in the letter that we received today from O'Donnell said that they didn't receive notices and there seems to be some sort of miscommunication between the petroleum office and their office. Can you just briefly describe how we're communicating with them? Is it through letter? Is it through email, phone? Just to kind of clarify that piece, that one of their claims in this letter.
Well, our initial communication with them was in April 18th of 2018, and that was the first notice of violation that was sent out. And we had a large meeting in October where there were a number of about 7 or so franchisees who were brought in for insurance issues, and they were getting notified at that point. And we're using our official date is, I believe, there was a March date of where we sent. There was, again, some dispute where they felt they were not, the insurance requirements were not applicable, and so we reissued something in March. And so that's, I believe, if we want to use the first violation, that would be the date.
So during this period of time, there was back and forth in terms of notifying them of their non-compliance. It wasn't like we were issuing it and not hearing a response.
We have, I guess as terms of timeline, our first notice of violation was April of 2018. Then there was a second notice of violation issued August of 2018, August 28th. Then there was a third notice of violation on September 12th of 2018. There's the big board hearing on October 26th of 2018. There is a hearing on February 25th of 2019. O'Donnell did appear at both those last two meetings. And on March 11th, there was also a board hearing about all these related to insurance requirements. And so we've been communicating via email. Our risk management office has communicated with them as well. So they have been notified in several different ways via letters, emails, phone calls.
And they've responded?
They have responded, yes.
Okay. Yeah, I just wanted to clear that up because I know here in the letter it says that they have received no record of a notice being submitted to them. And I don't know if you have a copy of this letter that they sent to us.
A number of those notices were attached. I believe we can go back in the records and get some from 2018 if you would like. We can do that.
I just wanted to clarify the
we have
record
of
and
those.
clarify
Yes,
that
we're
piece.
happy to provide that.
And then I'm sorry, when you said that these in-person meetings with the franchisees, did O'Donnell attend or not attend?
Yes, O'Donnell did attend on October 26th, and they attended on the February 25th meeting in 2019.
So essentially they've had since April 2018 to comply.
That's correct.
And for all the other franchisees that attended the meetings, for those that you were trying to get into a compliance, for those who are trying to abandon or in similar situations, do we have these similar issues with other franchisees, or do you feel like this is unique to O'Donnell just for additional context?
Well, of the 40 franchisees that we have, so far everyone else has been able to obtain the sudden and gradual pollution liability. It's just the two, O'Donnell and the other item on the agenda, Cooper and Brain, who are still missing the sudden and gradual $25 million pollution liability.
And there's how many franchisees again?
There are 38, or the total 40, but there are 38 others who have been able to find the insurance.
So 38 found a way to comply with all of our rules and regulations and get back to you in a timely manner, and 2 did not.
Yes, that's correct.
Okay. All right. Thank you for that context. Very helpful.
Thank you. My thought on this, Commissioner Colosa, I think you just did an excellent job of pointing out that we've got a problem franchise here. I even called it gamesmanship a couple of hearings ago when Mr. Coffey had asked us back in 2018 regarding the notice issue and made an issue about it, and I said, okay, we'll take your notice issue, and just go out 90 days or whatever it was, and that way we won't have the notice issue again. And he came in and still claimed that we hadn't met the notice issue. So I thought it was gamesmanship. So I reckon, and it's not my intent to reward that, by giving them the requested 90 days. What is my intent is the belief that, and basically taking the council's word that, and just a little deductive reasoning from my part, that the $25,000 would be better spent trying to find a consultant to get this thing abandoned. My goal would be to have them succeed on their abandonment plan. And if we don't get it in 3 months, then the $25,000 fine, we can assess the $25,000 fine, and if he wants to appeal that, he can go through the courts to do it. But at the risk of rewarding perhaps unprofessional behavior at some level on the notice issue, I'm proposing that we take the risk. But I'm also understand if any of my colleagues feel like they just can't go with that today. I'll put the motion on the table for a vote, of course, and I completely understand the concerns. Commissioner Garcia.
Thank you, President. I just want to say that I agree with both, actually, Commissioner Calosa and President James. And I think as the city and the stewards of the city, our overall goal is to complete what's best for the city. So at this point, I want to support your motion, President James, because I feel that our goal is that, to really get to that bottom line. And if in 90 days we don't succeed, then I think it's time for us to take action.
Okay. Commissioner Villegas.
I just want to put on the record, I appreciate the information that we have before us. There has been clear communication channels between Mr. Coffey's firm and the city of Los Angeles. I mean, it's all on our record. So there's, my opinion, it doesn't seem to be a gray area. I just wanted to state that because there's direct email exchanges.
I agree. I think it's the issue of notice has always been a bit of a game, but I'm still willing to see, because I believe while the issue of notice is a bit of a game, the issue of the penalty and money being used towards an abandonment, I think that's less of a game, and that's why I'm willing to take the shot. And admittedly, it's an incentive for them, and if it's the incentive that gets us over the hump with this franchisee so we can get it properly abandoned, I'm willing to take the risk. And it's not as if they haven't been penalized. They did pay the $10,000 penalty in September. Let's take a vote on the motion. The motion would be, it's my motion to continue this hearing. Although we may need to amend it regarding the designee issue on the Petroleum Administration Office. We, in essence, have our interim Petroleum Administrator in Ms. Blyther, so we need to put that language in regarding Petroleum Administrator or designee. But the substance of my motion is that we grant the requested 90-day continuance by the O'Donnell representative to continue this hearing on deciding whether or not we're going to assess the $25,000 penalty based on whether or not they have, in that 90-day period, submitted an abandonment plan that is satisfactory to our Petroleum Administration Office. So we're putting this hearing over 90 days. Do you have a question, Mr. Jordan?
Well, yes. So the report had a number of recommendations.
Yes.
So
Well,
some of the recommendations, if the board is desirous of, could be, you could take action today. Those are the findings relating to the submission and request of abandonment. Some of the recommendations are clearly within your putting it over 90 days. And then the last recommendation, I think, is not applicable because O'Donnell has a representative present at the hearing.
Well, I want to check on that one.
Okay.
So let's get through these. First of all, Mr. O'Donnell, let me go through, not Mr. O'Donnell, Mr. Coffey, let me go through my motion. Today, recommending that the board, my motion would be as follows. Thank you for the advice, Mr. Jordan. First, find that O'Donnell Oil LLC submitted a request to abandon its franchise ordinance number 181075 pursuant to section 4.7 of ordinance 181075. I would recommend that we agree with that we make that finding. So that would be section 1 of the motion. Section 2 of the motion, find that the abandonment plan submitted by O'Donnell Oil LLC does not meet the city requirements. I would recommend that we find that as well. And then number 3, instruct O'Donnell Oil LLC to submit an abandonment plan which complies with the city and Office of State Fire Marshal's requirements. I would recommend that we adopt that as well. Now we get into the ones that I would be inclined to address on a continuance type basis. Well, let's take number 4. Authorize the patrolman administrator to impose a $25,000 fine for ongoing failure to provide insurance at the level required by the Risk Management Division of the City Administrative Office, Chief Administrative Office. This one I would recommend that we hold over for 90 days. Number 5, find O'Donnell Oil LLC in continuing violation of Section 5.2, the insurance requirements of Ordinance Number 181075. We can do that today. They're still not there. We don't have to. We can decide in 90 days if we want to penalize them. So I would recommend that we adopt number 5 as is stated as well. Number 6, instruct the petroleum administrator or designee is the amendment I would make on number 6, comma, to issue a $25,000 fine for O'Donnell Oil LLC's failure to obtain and or provide evidence of $25 million in sudden and gradual pollution liability insurance. This is one that I would continue for 90 days, number 6. Number 7, order request from the Board of Public Works Executive Officer to provide written notice to O'Donnell Oil LLC of the board's action if a representative is not present at the hearing or will not waive notice. Here's my question for Mr. Coffey. I would request that in cooperation with what I'm putting on the table, Mr. Coffey, that you agree that you will not require written notification, that you'll waive written notification because you are here at the hearing this morning.
I will do so. I assume you're gonna give me a date that the...
Yes. We'll work with you on that date.
All right.
So that would be my motion, colleagues. So we're really, 4 of them we're finding as is. That would be numbers 1, 2, 3, and 5. And then numbers 4 and 6 we're putting over for 90 days. And number 7 we're about to get resolved with Mr. Coffey's representation on the record, provided we give him a date that works. What would be the 90 days out, Dr. Campos?
That would put you at Monday, February 24th, 2020.
Oh, my mother's birthday. Monday, February 24th, 2020. I expect to be here that day. Does that work on your calendar, Mr. Coffey?
That does, thank you.
Okay. Then we'll take that. I would recommend that date, and that will constitute a waiver of notice from you.
Agreed.
Okay. Thank you. So is there a second on that motion? By Commissioner Davis. Any opposition? Okay. Commissioner Caloza?
Is that Commissioner Caloza oppose?
Yes.
Thank
Any
you.
other opposition? Okay, so that'll be 4-1. So just so you know, Mr. Coffey, on a vote that's 4-1, I never ask for forthwith if it's not unanimous. So this action of the board will be final at the end of Wednesday's meeting. So there is a possibility that someone could recall the item on Wednesday morning. I'm not going to say that you need to be here, but you might want to listen in.
Okay.
Okay? And Dr. Campos can let you know how to do that.
Very good.
Okay? It's up to your decision whether or not you decided to be here or not. But
I am going to be out of town, so
Okay.
I can be here on Wednesday, but if that were to occur, I guess I'd find a way to call in.
Yeah, you could listen in. Yeah. All right, so Mr. Jordan, anything else?
No, it would just, given the waiver for the notice,
Yes.
I would maybe recommend that if, for any reason, the board does recall the matter on Wednesday, and that just, maybe you would request staff to send a notification to the council or otherwise, just advising them of, any changes or actions taken.
Yes.
Yeah,
Just as a courtesy.
That would be fair.
I don't have any problem waiving notice for the February meeting since you've just given it to me, but I would, if we're going to recall on Wednesday, I'd absolutely want notice of
That's
that.
his point, and I agree. I don't disagree with that at all. I would not ask you to waive notice on something that would happen when you weren't aware of it or notified of it.
Okay, I appreciate that.
Yeah, fair enough. All right, thank you then. That'll be the order this morning.
Thank you.
Okay,
Thank you very much.
Agenda item number 3. Hearing ordinance 184956 Request to impose second monetary penalty against Cooper and Brain Incorporated for noncompliance of insurance requirements. This is a second offense. Recommending that the board find that Cooper and Brain Incorporated was already fined $10,000 for the first violation within the last 12 months. Secondly, find that Cooper and Brain Incorporated remains in violation of Section 5.2, the insurance requirements of Franchise Ordinance Number 184956. Third, approve the monetary penalty assessed to Cooper and Brain Incorporated in the amount of $25,000 for failure to comply with Section 5.2 insurance requirements of their franchise ordinance. And fourth, direct the Office of Petroleum and Natural Gas Administration and Safety to issue a violation to Cooper and Brain for failure to comply with Section 5.2 of the franchise ordinance 184956. Mr. Sachs on number 3.
Yes, thank you again, Arnold Sachs. There used to be a cartoon called Pinky and the Brain. This is Cooper and the Brain. But it's also an incorporation, whereas the item number 4 was an LLC. And I appreciate the fact that some of the information that came out was there's 40 ordinances, 40, pipeline franchises throughout the city. That being said, it's all the CDs. So I don't see anything from the county here, but I hear the county. Because I imagine these pipelines going from east to west or north to south or whatever direction they head off into, and then they get to the edge of the city and they stop. That doesn't make sense. So they must run into the county somewhere. Or maybe they run through Beverly Hills. Or maybe they run through Santa Monica. Or maybe they run through any of the neighboring cities that surround LA. How does the city of LA get to decide what's happening with these franchises in the county? That doesn't make sense at all. And the amount of money that's being laid out here in fines doesn't make sense at all either. $10,000? It's less than $1,000 per council district. How does that work? And somebody mentioned that the fine had been paid for item number 4. Who got the money? If it goes to all CDs, who gets the money for the fines? Does it go to the city's general fund? Does it go to the petroleum office? Does it go to the state fire marshal's office? How does the funding get divided up? It's all answers. It's questions and questions and questions. I appreciate orange juice with pulp. That way you get to chew on some of the information. But sometimes you just get bananas. Thank you.
Thank you, Mr. Sachs. Ms. Blyther.
Good morning again, Erica Blyther, for the record. Thank you again, commissioners, as well as department heads. So Cooper and Brain, despite being issued a first fine being levied on the last 12 months for failure to provide sudden and gradual pollution insurance as required by their ordinance 184956, Cooper and Brain has yet to comply with that requirement. So as a result, the Office of Petroleum and Natural Gas requests that the Board of Public Works fine Cooper and Brain in continued violation of its franchise ordinance and authorize the Office of Petroleum and Natural Gas to issue a $25,000 fine for this continued violation. Again, it's the $25 million sudden and gradual pollution prevention or pollution insurance that they do not have. And they have been in contact with our risk management office in July as well as November, but they have yet to provide that insurance. Any questions?
I don't have any questions on this one, Ms. Blyther. Again, I think the board report let us know what's going on. Commissioner, at least let me know. I'm sorry, I speak for myself. Commissioner Caloza.
Thank you, President James. Did the franchisee know about today's meeting?
Yes, they were notified.
Okay. And they chose not to attend?
I don't see them.
Do you have anybody from Cooper and Brain here?
And in the series of meetings that you identified for the last item, did they attend as well, or was there a representation?
They did attend, I believe they attended, I do believe they attended the October meeting. And again, all of the franchisees were notified when they were not in compliance with the information back in, I believe, April, and then we had a big meeting in October, and they were one of the meetings in October of 2018 where they attended. And there they had requests for deferring. I'm not sure if they attended in April. They did not attend in April.
And we didn't receive any supplemental documents from them. I don't know if Dr. Campos can confirm that, whether or not we received anything supplemental like we did from the last applicant, since they didn't attend or aren't in attendance today.
So the notice was sent out on November 5th, 2019. I can follow up with them just to clarify, because we are having, it is a different date than the November 15th date. But we can follow up with Cooper and Brain and provide this notification. If the board would like to continue this item for another 2 weeks, we can give a more formal notification to Cooper and Brain, and then also provide them certified notification or certified mail notification so that we can get a return receipt that they have been properly notified.
I believe we had emails confirming that we've had email.
We have email communications that are in the record from Cooper and Brain.
We do, however, the letter does indicate November 15th.
It's November 15th, I think.
November 15th as the actual hearing date as opposed to today's date. So we have one set of communication records saying today's date. Our letter indicates November 15th.
Yes, just for clarification, as Executive Officer has indicated, the third notice of violation was a letter sent on November 5th.
Right.
In that November 5th letter, the third notification, it indicated that the Board of Public Works would be having a meeting on November 15th at 10 a.m. Regarding the monetary penalty. I'm not sure what transpired between November 15th, the date in this notification letter, and today, but I think what we're suggesting is perhaps a additional communication to establish that date, unless for some reason the applicant was told on the 15th, no, it's going to be heard at a later date.
Did we agendize the item for the 15th and then continue it to today? Because it doesn't, I don't see a continuance notice.
No, this is not an advisement item, so I would recommend that we continue this item for 2 weeks so that I can give proper updated notice. Even though our emails indicate that it is going to be scheduled for today, our official letter signed from our patrolman administrator does indicate November 15th. So I think in the best interest and just for due process and just notification to the client or to the franchisee, it's best to send out a letter today, send it out certified mail, get a return receipt letting them know that we would continue this item for 2 weeks if this board would like to continue it to Monday, December 9th, 2020.
That's fine, but were you here on November 15th?
I don't believe this is agendized for the 15th, but we did email them on the 20th to let them know about this change date.
Emailed them on what date?
The 20th of November.
The 20th?
So they
received
5
days ago?
Yes, 5 days ago.
Via email?
Via email.
Okay. I guess my question, though, even though it wasn't agendized for the 15th, did we have anybody that you know of, Dr. Campos, show up on the 15th? The reason I'm asking is they received a letter, ostensibly, from us saying it was going to be on the 15th. Whether or not they look at an agenda, they could act on that letter and show up or not.
I don't recall anyone coming in from Cooper and Brain, but I could go through my records to verify that, but I want to say no.
We don't have a choice here. We've got to continue the item. I think, given the confusion, even though we provided email notice, was there any response to that email notice?
I believe.
We're looking.
We're looking right now.
Because if there's a response to the email notice, then they had notice. Can you come up to the microphone, please?
Tamara Martin, Office of Petroleum. There was also email contact with Mr. Cooper on the 12th of November, advising him that we would not be proceeding on the 15th and that we would be in touch with the new date. And then he was advised of the new date of today.
Okay. Was there any response from him acknowledging the notice of today's hearing?
1 moment. No, we did not have a response from him on today's meeting. We had one when we thought we were going to be moving it to the 22nd, I believe. We received a thank you. So the email is valid, the address is valid. We certainly have had contact, business contact with him at it reasonably consistently.
And do we have as far as we know, a correct address for them too?
Yes.
Okay, then I would be inclined to, I know that Commissioner Villegas, you have questions. Would be inclined to, and you're not done yet, Commissioner Closer?
It's okay.
I'm sorry. But you sparked this one. So as far as continuing it, let's go ahead and get our questions done. I recognize that we may have to continue this item. Okay. Commissioner Caloza.
No, it's okay. It sounds like we're going to continue this item, so I'll reserve my questions for the rescheduled hearing date.
Okay.
Thanks.
Commissioner Villegas.
I just had a clarifying question. It seems like this is a new process since trying to get all the franchisees up to date with their insurance requirements.
Yes.
And since this is the second notice, I'm wondering if this office has had a franchisee that has been imposed a fee come back and ask if the fee can be waived prior to this board taking an action. Actually, after this board has taken an action, excuse me.
So I believe in October, there were a number of franchisees that were going to have fees, and then we continued that and said, let's give you some time to get your insurance together. So that was back in October of 2018. And again, we've been working on this insurance compliance program since April of 2018. There were a number that complied, and then there were about 7 in October of 2018 that had still not complied. We gave them a continuance time to get insurance, and so we, in essence, kind of held that fee and didn't fine that. And now we're actually assessing the fines because it's now November of 2019. So it's been over a year where they've had time to gather insurance.
Anything further? Okay, your recommendation, Dr. Campos and Mr. Jordan, I'd like you to chime in on this as well, is to continue this over 2 weeks to provide additional reasonable notice to the respondent to either show up or not, but at least to have notice.
Correct.
Yes, I agree. And I would suggest mailing a notice and also separately emailing, just 2 different forms of sending it.
Right. You know what we could do, Mr. Jordan? Could you does it make sense to give our petroleum office a proof of service to attach to a mailed notice so that we have something that's additional in our record to verify that we sent? Does that make our issue on notice any stronger to attach a proof of service?
I don't think we necessarily need to do that. If you want to strengthen the mailed notice, you can do a return receipt type mailing. But I don't think, unlike a court pleading, we necessarily need to have that proof of service document.
I just think a proof of service is easier standard than a return receipt requested. Sometimes you get those, sometimes you don't.
We can
if they know you're about to find them, why would I sign a return receipt requested? Go ahead, Dr.
And we can do certified mail, sending it over to us just so that we can have a USPS tracking confirmation. We won't necessarily get the return receipt if we don't like to, or we could add it, but at least we can at least deliver the mail, the letter.
It gives us some element of proof that we sent the document.
Yes, I think that's a good idea.
Okay. We just want to I want to make this wiggling out of notice as hard as possible. Then you can work with Dr. Campos on the mail procedure for this respondent on the hearing on December 9th, you said, Dr. Campos?
That's correct.
Okay, that's 2 weeks from today. You know what, would you move it to the 11th? I'm not going to be here on the 9th.
Wednesday, December 11th?
Yeah.
Wednesday, December 11th is a tentative off-site meeting with Council District 3.
So it sounds like it's going to be Friday
the 13th.
Yeah.
Okay.
So that'll move it to Friday the 13th. It's even more time for them to get notice. Okay, and then, Ms. Blyther, your office will send, since it appears that we do have a good email address, send the updated notice about Friday, December 13th for the new hearing date on this.
Sure.
For this franchisee. Okay, thank you. Then any objection to that? That'll be the order. Thank you, Commissioner Closer. Anything further? Okay. Dr. Campos, does that mean we've cleared the desk today?
Yes, you have.
Well, how about that on a Monday morning? Everyone have a nice week. We are adjourned. We are in session on Wednesday morning. So, Mr. Sachs, we'll see you on Wednesday morning. We are adjourned.